Welcome to The Explainer, where we break down complex issues using the documents at the heart of the story. And today we're looking at a pretty wild legal battle. See, it's not the defendant versus the prosecutor. This is the defendant versus the judge. The one person who holds his entire fate in their hands.
Whoa. You just don't hear a judge say that to a defendant, in open court, no less. And look, that one really charged statement, it's not just some random heated moment. It's really the tip of the iceberg of a conflict that gets right to the heart of our entire justice system.
So what happens when you're the one in the hot seat and you believe the judge in your case is actively working against you? Well, today we're going to dig right into the formal documents filed by that defendant, a guy named Lonnie LuPardus. He's actually trying to get Judge Thomas Sutherland thrown off his case. We're going to follow the paper trail and see just how things got to this point. All right, so let's start with the defendant's accusation. To really get what's going on here, we first have to understand what it actually means, legally speaking, to ask a judge to step away from a case. Okay, before we get any deeper, let's lock in this key term, judicial recusal. Think of it like a critical safeguard. It's the legal eject button, designed to make sure the person making these huge, life-altering decisions is a neutral referee, not, a player for the other team.
And this is really important. This isn't just some casual complaint. The defendant, Lonnie LuPardus, filed a formal affidavit. That's a sworn legal statement. He's not just griping that the judge is unfair. No, he's alleging a clear pattern of judicial bias. He's basically saying the judge is so far from neutral that a fair trial is completely impossible.
So, this affidavit, it doesn't just make a big, vague claim. It tries to build its case using some very specific examples. So let's break down exactly what the defendant is alleging here. Okay, so a huge part of the argument boils down to this: a feeling of totally unequal treatment. LuPardus claims that in the courtroom, it felt like the prosecution could just talk and talk, present their evidence, no problem. But when it was his turn, he says he was consistently shut down, and his ability to even question witnesses was restricted. And then there's this. LuPardus points directly to the judge's own language. The affidavit calls out this little Johnny analogy and argues the judge used it to be patronizing, to basically dismiss his very real legal concerns as if they were just childish complaints. Now, this next claim is, well, it's pretty striking. LuPardus, who was representing himself at times, alleges that his legal motions were just dismissed out of hand. But then, when his attorney later filed a motion with the exact same arguments, word for word, the judge suddenly praised it as well-reasoned. You can imagine, for the defendant, that felt like a huge double standard. The affidavit also gets into the defendant's struggles with his third court-appointed attorney. This communication log is basically Exhibit A. It shows a whole string of emails from the defendant to his lawyer in the weeks right before trial, and you can see almost no responses. LuPardus is using this to show a complete breakdown in his legal defense, a problem he says the judge just turned around and blamed him for.
And it seems it wasn't just the defendant feeling this way. To back up his claims, the affidavit includes this quote from his second attorney. He's describing a hearing where he felt the judge just walked in with his mind already made up. He said the hearing itself felt like it was just house cleaning, like the real decision had already happened behind the scenes.
Okay, but that's just one side of the story, right? To get the other side, we have to turn away from the defendant's claims and look at the judge's own words, which are all documented in the official court record.
So in his official ruling, the judge lays out his logic, kind of step by step. He points out, 1, the defendant has already had 3 different appointed attorneys. 2, he says they're all skilled and experienced. 3, he argues that the defendant's own actions have gotten in the way of moving the case forward. So his final conclusion, step 4, is that the defendant has forfeited his right to a lawyer paid for by the court.
So from the judge's point of view, the defendant cycling through lawyers isn't bad luck or bad representation. He sees it as a deliberate tactic. He literally writes that the defendant's goal seems to be to dictate legal strategy or to hinder or delay the proceedings, basically a stall tactic. But here's where the defendant's filing pushes back hard. It points to what it calls a major contradiction. The question is this:
If the judge really believes this defendant is impossible to work with, then why on earth would he offer to reappoint one of his former attorneys to the case? It's a direct challenge to the judge's whole line of reasoning.
So you've got these two totally clashing narratives. What's the actual legal path forward here? How does a defendant even go about formally asking for a new judge? Well, the defendant's request isn't just based on a feeling. It's grounded in specific Kansas state law. And the rules are pretty clear. They say a judge has to step down if a sworn affidavit establishes bias, or if their impartiality could reasonably be questioned. And that last part, reasonably be questioned, that is the key legal test right there. And so after laying out all that evidence, the affidavit ends with a very direct, very formal request. He's asking the court to do three things. 1, remove Judge Sutherland from the case. 2, have the chief judge assign a brand new judge. And 3, make sure that new judge is fair and has no bias or prejudice. So when you look at all the documents, you're left with these two completely clashing realities. On one hand, is this just a judge trying to firmly manage a really difficult case and a difficult defendant? Or, on the other hand, are we seeing genuine, unacceptable judicial bias? And the big question is, where do you draw that line? Because where that line is drawn, well, that defines everything. It really highlights the incredible power and the incredible responsibility that a judge holds in a courtroom.